You may be seated. Thank you. Before we go on the record, we will have a moment of silence for 9 to 5 in memory of Dolly Parton. I'm just kidding. Anyway, we lost a great person in the loss of Dolly Parton. Thank you. Let's go on the record. This hearing will come to order. For the commission today is the continuation of the hearing in docket number 26009U, which is styled in the matter of an investigation of the sale of Energy Arkansas LLC's nuclear production tax credits and a determination of the treatment of all other tax credits. This hearing was continued from July the 9th, 2026, and scheduled by order number 8 in this docket on July 30th, 2026. Of note, be sure that your cell phone is turned off. If you need to speak on the cell phone, go out in the hall. If you wish to connect to our Wi-Fi system, you can log in at APSC guest, and the password is welcome 2026. For the record, will the attorneys state their appearances and the names of those persons they intend to call as witnesses? Ms. Law?
Good morning, Jana Law for Entergy Arkansas, and I have with me Karis Kearney and Jay Breedfeld as counsel. We have 7 witnesses today: David Palmer, David Batten, Paul Schott, Stacey Whaley, Rob Harrell, Jay Chang, and Jay Lewis.
Thank you. Welcome to the 2 attorneys. Welcome. Mr. DePippa?
Joel DePippa, Arkansas Advanced Energy Association. We have no witnesses to present.
Mr. Attorney General?
Michael Coots with the Attorney General's office. We also have no.
Mr. Parks?
Thank you, Chairman. Miles Parks, I represent the staff of the Arkansas Public Service Commission. I have with me the co-counsel today, Wes Manis, Clay Lacey. Our sole witness today is Jeff Hilton.
Thank you. Would those who intend to testify please stand and raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. You may be seated. It's my understanding there are no public comments. Is there anyone in the room that wishes to make a public comment concerning this matter before we proceed? Seeing none, we'll deal with some procedural matters. The pre-filed testimony is admitted into the record. It will not be duplicated in the transcript of today's live hearing. Energy is instructed, you may be aware of this if you're not, Energy is instructed to refile and appropriately label their supplemental exhibits, specifically Excel-based exhibits that have been filed without proper exhibit labeling. They apparently don't tie to the testimony, and it's hard for us to sort out which ones tie with which testimony. Is that correct? Yes.
Yes, sir.
Yes, thank you. Also, please note that the Commission's long-standing hearing rule will be in effect during the hearing, meaning that once the hearing witness has been tendered for questioning by the Commission, further redirect of the witness by counsel will not be permitted. Further, the parties are reminded that this case may include protected information including highly sensitive protected information. Members of the public are advised that the hearing room may need, from time to time, be cleared, with the exception of persons who have signed the proper affidavits of non-disclosure. Parties are advised to inform the commission if and when a party intends to reference confidential information, in which case the commission can determine whether to go in camera. Are there any other motions that we should consider at this time? Ms. Law?
Entergy Arkansas enters its standing objection to the application.
Let me ask you to do this. Go to the lectern. And I want to encourage all of you to go to the lectern if you wish to speak to the chair so it's picked up. Thank you.
Certainly. So entering our standard objection to the application of the rule.
Oh, of course. It's overruled. Thank you. There will be no opening statements since we previously had opening statements. Mr. Bridwell, would you call your first witness?
Jay Breedveld for Entergy Arkansas. We'd like to call Mr. David Palmer.
Welcome, Mr. Palmer. You never make it over here.
Thank you.
All right. You need a water, sir.
I'm good right now.
Okay.
Pull that mic a little closer to you.
Yeah, it gets kind of warm.
Good.
Mr. Palmer, please state your full name, title, and business address for the record.
John David Palmer, Vice President, Regulatory Affairs for Entergy Arkansas, 425 West Capitol, Little Rock.
Are you the same Mr. Palmer that provided supplemental testimony and exhibits on August 14, 2026 in this proceeding?
Yes,
And if I asked you the same questions in that testimony today, would your answers be the same?
they would.
All right. Consistent with the chair's statement that your testimonies and exhibits have already been entered into the record, we'll tender you for cross-examination.
Thank you. It's admitted. Mr. Parks, do you have cross-examination?
Thank you, Chairman. Good morning, Mr. Palmer.
Morning.
Under EAL's originally proposed nuclear production tax credit rider, if the IRS disallows 100% of the claim tax position, EAL seeks to recover 100% of the resulting taxes, interest, and indemnification costs from retail customers. Is that correct?
Bear with me. Can you show me the testimony on the original proposal where it says that?
I believe it's in your supplemental testimony, page 6 and 7.
Thank you. Just let me confirm one thing.
And also it's in the MPTC rider. And that was kind of the basis for the question. The proposed rider in your filing.
Right.
I think it's 74.4.
Well, if I'm recalling correctly, the proposal in the rider, the initial proposal was we would set aside the net proceeds of monetization for the credits. And during the pendency of resolution, we would provide customers the benefit of a WAC return on those net proceeds. And then customers would wear the risk of those costs you outlined with respect to the level of benefit they receive through the WAC return.
Okay. In the first hearing, there's a fair amount of questions regarding penalties, IRS penalties specifically.
I would not be the expert on IRS penalties, but I think there is you would distinguish a penalty from losing the position in terms of how we've claimed the credits. Those are distinct issues.
Were you here for the first hearing?
I was not.
Okay. Mr. Lewis in that hearing indicated that IRS penalties would not be included.
I believe that is correct because, again, IRS penalties would be a distinct issue, separate from resolution of how we calculated the tax credit amount.
And if so ordered by the commission, would you be willing to specify or clarify that in the filed tariff? That-
Sure. Yes.
To mitigate customer risk, EAO has modeled an alternative debt return scenario modeled after the Mississippi Public Service Commission's approved framework, where customers bear 0% of the indemnification costs in the event of an unfavorable IRS determination. Is that correct?
That is correct.
And under that Mississippi-style debt return framework, if the IRS ultimately disallows the credits, EAL shareholders rather than retail customers bear the contractually assumed financial loss. Is that also correct?
I don't know if I would I would describe it as shareholders would suffer a loss. I think what our proposals are at a high level are a representation of a balance of the risks that customers would wear relative to the benefit they receive. In the, excuse me, in what I believe you're calling the EML approach, what we would do is during the uncertain period while we're waiting on resolution from the IRS, we would accrue a debt rate on the net proceeds, but we would not be giving customers a direct bill credit, if you will, of that accrual. We would hold that until resolution, and then upon success, customers would receive the net proceeds and the accrual of the debt rate. So in that instance, customers haven't received a benefit during this uncertain period, so there wouldn't be a reason for customers to wear risk.
So to be clear, customers wouldn't be responsible for the loss.
That's
Under
right.
the
Yes, under the
Mississippi.
Mississippi approach, that's right. The company would still have the proceeds. I mean, we've obviously used the proceeds to help support the business, but the company would give customers. There would be no proceeds to then give customers if it's disallowed. So customers are indifferent to that outcome.
That's all the questions I have, Chairman.
Thank you. Any redirect, sir?
Yes, sir. Mr. Palmer, you were just speaking to a balancing of risk in the context of options to return the production tax credits to customers. You recall that line of questioning?
Yes.
All right. And do you have a point of view on whether Mr. Hilton's proposal in this proceeding offers a balancing of risk?
I do have an opinion, and I believe we've expressed it in testimony that it don't view it as being symmetric or reasonable or whatever description you would use for customers to receive a benefit that is in excess of their risk. And under staff's proposal, I believe the company would be being subjected to an arbitrary disallowance of up to 20% of those costs. So customers would be getting a benefit that exceeds the risk that they're wearing. So I can't see that as being a reasonable recommendation.
That's all.
Thank you. Ms. Anderson,
No questions right now. Thank you, Chairman.
Mr. Tate?
Thank you, Chairman. You talked a little bit about the new proposal, but why don't you just give us an overview on the new proposal that was presented in the supplemental filings?
The new proposal being the approach used in Mississippi.
Yes.
So if it may be easier just to compare it to what we proposed or where we were trying to go. So in our proposal, in our direct filing, we were saying we obviously have this uncertain period, and to the extent the principal amount, those net proceeds, are given to customers, then the expectation is customers are wearing the risk of the disallowance, the clawback of the benefit they received. Our approach was to say we can, I'll say, de-risk that for customers by not giving customers those net proceeds until we have resolution. But to get customers some value in the interim, we propose to apply our WAC return as a rate that we would accrue interest on the net proceeds and give that direct benefit to customers today, in exchange for a commensurate level of risk on the back end if it's ultimately clawed back, but capped at the benefit they received. Under the Mississippi approach, you have a similar situation with respect to the net proceeds. They are not utilized in rates until you have resolution from the IRS and you know whether you're successful or not. In the interim, you accrue a debt rate return, but you don't provide the customer the benefit. So upon unsuccessful resolution, customers haven't received a financial benefit, so they wouldn't be exposed to any financial consequence. You could look at, and I think about it this way, Commissioner Tate, you could look at, like there's a history here with respect to the nuclear production tax credits, right? I've said all along, there's a fair amount of uncertainty relative to how that plays out for rate making, because until we have guidance from Treasury, we don't know. We don't have, wouldn't say we necessarily would know. We don't have a high degree of confidence, right, that we're going to be successful in how we've calculated the value of the credits. And I know our tax folks back there know I'm butchering that language, but until we have that, we can't move forward with a definitive proposal. Like on the solar, it's very well established how to quantify those tax credits. That process is known. There's some history, so we have a high degree of confidence. We know what to do. We have taken the approach of waiting until we have that guidance so we don't have to manage this risk for customers. But unfortunately, we've gotten to the point where that guidance is now, not going to come out in time for the 2024 tax credits to be monetized. So in effect, you could think about the Mississippi approach as really maintaining the status quo we have today. We're still waiting on guidance. We're not going to do anything until we have it. But recognizing that the company does have access to the net proceeds to help fund the business in the interim, we can treat those net proceeds like any other source of external financing, like debt, and accrue that debt rate so that when customers do get the benefit, they also get, call it a time value of money, but something that looks like a debt that we owe customers. But they're not wearing any risk. So effectively, you're just waiting until you have resolution, which has been our goal all along. But unfortunately, you have to make these elections annually. So if you don't do it in the tax year, you miss the opportunity.
So the first proposal, the interest accrued at the WAC rate would flow back in the interim to customers, correct?
Correct.
And the net proceeds would be used to fund the business until a determination is made?
The net proceeds would go in just like any other proceeds, and yes, used to support the business.
Would you say that's a benefit to the business?
It's a source of income for the business. That's really all I would say. There's no, let's take this amount and go, apply it to some shareholder's bank account. We have a capital plan, we have O&M associated with that capital plan, and we have a finite amount of sources of income to fund it. This is obviously a source of income to fund that plan. And then the outcome comes with however we manage the business. But there's no direct benefit to shareholders because we have the proceeds any more than there is if we go borrow $1 billion from a bank. We just have the proceeds we need to fund the business.
So I guess I need to clarify, your initial proposal is what we were talking about with the WAC in the interim, net proceeds after an IRS determination. In supplemental, you've proposed an alternative. And to clarify, EAL will bear all of the indemnification risk associated with that, correct?
Correct. And in the EML approach.
Right.
Yes.
Are you still asking us to consider the initial proposal, or are you now just asking us to consider the alternative proposal?
I think what we're doing is trying to correct a gap we had in our original filing. Clearly, there was some more information needed by the commission to evaluate this proposal. When we started out in 25 with how we consider, what are we going to do about this issue? You're into the first quarter, there's a new administration, there's now a change in circumstance where we don't expect Treasury is going to help us out. Until that point, we thought by the time we got to a proposal for how to handle the nuclear production tax credits, that would be in hand, and it would be an entirely different calculus for the commission. And that could play out in advance of us needing to get that done for our return in October of 25. When that changed in the first quarter of 25, we got comfortable, and this is in my testimony, moving forward because we knew there were several alternatives to how you would approach the rate-making impacts. Clearly, claiming the PTCs for the nuclear asset is the right decision because there is no alternative. If you want the benefit of the tax credits, that's your only option. The question of whether to monetize was the one we were evaluating. And all of our analysis, showed that monetization produced more potential benefits for customers than utilization for a host of reasons. But at 50,000 feet, it's fairly intuitive. You can collect cash today with acknowledging a modest discount, but the alternative is you don't, and you don't really know when you will be able to capitalize on utilization given other tax factors. And so obviously $1 today is worth more than $1 in the future, especially if the risk around that $1 in the future has other things attached to it that are going to play out on that tax return. So we got comfortable with the decision to monetize because that gave us the maximum opportunity for customers. What I'm saying we didn't do a good job of explaining was there are multiple ways of now reflecting the rate making of that monetization. We had spent time working with general staff to try to come to an amicable resolution where their feedback was, we prefer an approach where customers receive some benefit today. And that was the WAC approach. We can do that. Here's how we believe that would work. There's certainly the other alternatives. We just weren't going down that road. So when we made our initial filing, we weren't really saying to the commission, we recommend doing that. But fair assessment, right? There are ways to do it. The EML approach would be another option for the commission to, de-risk or give customers a level of risk you're willing for them to wear, but preserve the opportunity for the full net proceeds when the time is right.
So it's not that you favor one proposal over the other. You're just now presenting us with options.
That's right.
Okay. So I think we're clear on the indemnification risks associated with the new proposal. EAL ratepayers would also not be on the hook for any costs not recovered by the other operating companies who acquire capacity and energy from the nuclear facility through the EPSA or the EMSS4.
We would not be required to pay for costs not recovered
by the other
sure.
operating companies.
Meaning if those operating companies are not allocated those costs, or if they're somehow disallowed from their rates?
If they're disallowed from the IRS, we're not going to be on the hook for any of the...
Oh, right. It would be the same. It'd be the same economics regardless of which unit generated the credit.
What have you thought about the process for notifying us once the IRS has made a determination?
I believe we have a requirement to notify you within 30 days. I don't know if I've spent time thinking about the form that would take, if that's the question.
And I don't think it was in your testimony, but it looked like there were potentially 3 options where that notification might be triggered. Whether it was
How we got the resolution.
Right. Whether it's IRS guidance, whether it was that,
right.
statute of limitations,
yeah, you can,
2030.
I think the second two are kind of the same one in 2 different ways, right? Certainly if Treasury issues guidance on the issue, then all the taxpayers will know how to calculate it, or have a high degree of confidence in how to calculate it. If in the absence of guidance, yes, we would wait on resolution through our audit process of the 2024 tax year filing, because that's the first year we could claim the credits. Or otherwise, however statute of limitations plays out if the IRS doesn't address it.
So absent direction from us, is Entergy intending to just file something in this docket once it has resolution on that?
We certainly could. Like I said, I'm sitting here today. I don't know that I've spent a great deal of time thinking about the format of how we would notify the commission, but we could put it here or we could put it in the rate case or anywhere. or whatever's most convenient if it's a different type of notice. I'm just not remembering that the directive specified where or how. It just said, tell us within 30 days.
So the proposals are somewhat forward-looking as far as what rate would apply to the proceeds in the interim after a commission order. What rate would apply to the proceeds since you've acquired them up to a commission order?
Well, if the commission accepts our proposal, we would accrue the WAC rate back to when the funds were received.
And if we go with the alternative proposal,
I think we would apply the debt rate back to when the funds were received.
what is that debt rate?
That is a good question. I don't know that I could tell you the exact rate that was used in the analysis.
Do you know where it came from?
I would assume our most recent mortgage bond issuance, but don't hold me to that. We can check. That's probably a question I'm sure Jay or Mr. Schott know because they did the analysis.
Okay. Well, I appreciate the supplemental testimony that's been filed. I likely won't have a lot of questions today. A lot of the questions that were raised at the previous hearing have been addressed in that supplemental filing. And I do appreciate you guys bringing us alternative proposals to consider as part of this process. So that's all I have. Thank you, Chairman.
Thank you.
Mr. Palmer, thank you for your testimony.
Thank you.
Have a safe drive home.
Oh, I get to leave? I'll stick around.
I wouldn't let you leave for all the money in the world. You may proceed.
So our next witness is David Batten. Mr. Batten, please state your name, title, and business address for the record.
My name is David Batten. I'm the Senior Manager of Accounting Policy and Research, and my business address is 639 Loyola Avenue in New Orleans.
And can you please just describe your role within the company?
Yes, as the Senior Manager of Accounting Policy, I evaluate complex or unusual transactions for all of energy operating companies, including those for Energy Arkansas, such as the transactions accounting for the nuclear PTC monetization and the treatment of those proceeds.
EAL tenders the witness.
Thank you. Mr. Parks, any cross?
Chairman Webb, no, I don't have any cross with this witness. I haven't seen any testimony. I have no question.
Thank you. Ms. Anderson,
No questions, Chairman. Thank you.
Mr. Tate, you may stand down.
Thank you.
Thank you.
Mr. Chair, our
You
next.
say Parham or
Oh, the N is pronounced. It's Parnum.
Parnum? Okay, very good. Thank you. You'll have to get close to the mic.
Yes, Chair.
Thank you.
Mr. Chair, our next witness is Mr. Paul Schott, and we had also presented a motion in our email to the Chief ALJ requesting if it's the chair and the commission's preference to present our next four witnesses as a panels.
And who would those four witnesses be?
They would be Mr. Schott, Miss Whaley, and then Mr. Chang and Mr. I was trying to remember the order. Thank you. And Mr. Harrell.
Do you have any objections? Do you have any objection? Mr. Parks, do you have any objection?
I don't have any objection. I think I can manage if it's the chair's desire to.
You are a smart man. Thank you. Thank you.
Do that. Thank you.
You may call your panel.
Thank you, Chair. Mr. Schott, Miss Whaley, Mr. Chang, and Mr. Harrell. And
Be sure and bring your name. Yeah, there you go.
yes, and we request the indulgence to set
And
the room up.
have to pull a chair up or two. Yeah. You may have to share a microphone or two. I appreciate the motion.
One other preliminary matter, Mr. Chair. Ms. Whaley and Mr. Schott have brought laptops that contain relevant files, including the Excel files that were attached as exhibits to their testimony for purposes of efficiency in the hearing and being able to answer the chair and commissioners' questions.
They may proceed.
All right, I'll start with Mr. Schott. Please state your name, title, and business address for the record.
My name is Paul. Is this live?
Yeah,
My name is Paul Schott. My title is Director Tax, and my work address is 639 Loyola Avenue in New Orleans.
Are you the same Mr. Schott who provided supplemental testimony and exhibits on August 14, 2026?
I am.
If I asked you the questions in that testimony today, would your answers be the same?
They would.
Consistent with the chairman's statement, each of these testimonies and exhibits are part of the record, and EAL will tender this witness with the panel. I'll introduce Ms. Whaley next. Ms. Whaley, please state your name, title, and business address for the record.
My name is Stacy Whaley. My title is Director, Tax Regulatory, and my business address is 639 Loyola, New Orleans, Louisiana.
Are you the same Ms. Whaley who provided supplemental testimony and exhibits on August 14, 2026?
I am.
If I asked you the questions in that testimony today, would your answers be the same?
They would.
Consistent with the chairman's statement, each of these testimonies and exhibits are part of the record, and EAL will tender this witness with the panel. Mr. Harrell, would you please state your name, title, and business address for the record and your role here today?
My name is Rob Harrell. I'm a principal in Ernst & Young's National Tax Practice. I am based in Philadelphia, Pennsylvania at 2005 Market Street. My role today here is to answer any questions that the Commission may have regarding EAL's compliance with the prevailing wage requirements associated with the nuclear production tax credit.
EAL will tender this witness with the panel. And finally, Mr. Chang, please state your name, title, and business address for the record.
My name is Jay Chang. I'm a managing director at CCA Group. My business address is 1 Boston Place, Suite 3825, Boston, Massachusetts.
Are you the same Mr. Chang who provided supplemental testimony on August 14, 2026?
Yes.
If I asked you the same questions in that testimony today, would your answers be the same?
Yes.
Consistent with the chairman's statement, each of these testimonies are part of the record, and therefore Entergy Arkansas tenders the witness.
Thank you.
Thank you, Chair.
Welcome to Arkansas. Mr. Parks. When you direct your questions, will it be to the panel or will you have questions directly?
Well, the way I've got it structured is to specific witnesses, but
Okay. That's fine.
presume if you so desire, you
No,
can take
that's fine.
anybody's
I
answer.
just wanted the court reporter to know how you would be doing that. Okay?
Correct. I'm just going to start with Mr. Paul Schott.
And go down the line.
Yes. Well, so I've got Paul G. Schott, Stacy L. Whaley, Y. J. Chang.
Yes.
Didn't want to mess that up. And then J. A. Lewis. Now, I don't have any questions for, I believe it was Mr. Burrell. Is that Harrell? Harrell. Sorry.
Harold.
Harold, I didn't prepare any questions for him simply because there were no testimony from him in the record.
You may proceed.
Good morning, Mr. Schott.
Good morning.
Under the Accounting Standards Codification ASC 74-10, EAL has recorded a full 100% reserve against the entire value of the nuclear PTCs claimed for both 2024 and 2025 tax years. Is that correct?
That's correct.
Is it also correct that EAL recorded this 100% reserve because under the general GAAP, generally accepted accounting principles, the company cannot make a positive assertion on the technical merits that the claimed tax position is more likely than not to be sustained upon IRS examination.
That's correct. And I would add that that's a technical merits standard that is applied under the accounting standards, which includes the statute, the tax code, regulations, rulings, and any case law.
And is it your opinion that it is more likely than not, that this more likely than not standard, is it your opinion that the IRS will not uphold this?
I really don't have an opinion on that. I have an opinion on what the accounting standards require. And of course, that requires us to assert that we will sustain the position based on an examination by the IRS with full knowledge of all the facts. And we are not able to make that assertion in this particular instance.
So it's fair to say today you're uncertain. You don't have an opinion, or you're unclear as to whether you can declare that the IRS is not likely
it's
to
an
uphold.
Uncertain tax position, and we've treated it as such in the financial statements. That's correct.
And the total amount of Arkansas-related nuclear PTCs subject to this uncertain tax position is approximately $243.5 million for the 2024 tax year, and $116.2 million for the 2025 tax year. Is that correct?
That's
I could
correct.
point you to your testimony
that
if I
is
need
correct.
to. Okay. Is it correct that you do not expect an IRS audit or final resolution of this tax position to occur until approximately 2030?
That's correct. Our experience with the time frame for audits to resolve takes about 4 to 5 years from the point in time in which the tax return is filed.
And under EAL's executed transfer agreements, if the IRS disallows the tax position, EAL is contractually required to make the third-party buyer whole by reimbursing the initial sales discount and paying IRS assessed underpayment interest. Is that correct?
That is correct.
And under IRS Code Section 6621, this underpayment interest compounds daily on a daily basis. Is that correct?
It is.
And because this interest begins accruing from the original due date of the tax return, by the time the audit concludes in 2030, assuming that happens, EAL will have accrued roughly 5 years of daily compounding interest. Is that correct?
That is correct.
And isn't it true that in a 100% unfavorable IRS outcome, EAL's monetization path results in significantly higher dollar losses than if EAL had simply utilized the credits due directly to the buyer's discount and daily compounding IRS interest?
Well, I would say that the monetization provides greater value, and it also entails greater risk than utilization. So it's on both ends of the spectrum. I agree. Yes.
That's all the questions I have for Mr. Schott.
Proceed to your next witness.
So, good morning, Ms. Whaley. My next round of questions was for you.
Good morning.
Is it correct that under the Internal Revenue Code Section 45U, for the 2024 tax year, the nuclear PTC value is completely reduced to zero if a facility's average gross receipts reach $43.75 per megawatt hour or greater?
That is correct.
And in calculating gross receipts for Arkansas Nuclear 1, Units 1 and 2 EAL relied on payments received from the MISO market for generation and capacity. Is that correct?
That is also correct.
Is it correct that the Energy Corporation reported a net operating loss carryforward (NOLC) of approximately $18.8 billion in its last Form 10-K?
Yes, that is correct.
And because of this $18.5 billion NOLC, net operating loss carry forward. Energy Corporation currently has zero consolidated federal income tax liability to offset. Is that correct?
In the last filed tax return, there was zero tax liability for Entergy Corporation to offset. I also believe in Mr. Schott's testimony. He provides some data around the forecast, but we wouldn't be able to talk around that without going HSPI.
And if EAL had not monetized the 2024 nuclear PTCs by the extended tax return filing deadline of October the 15th, 2025, EAL could not have realized any immediate cash value for those credits. Is that correct?
That's correct. The PTCs have to be, sold and monetized prior to the filing the extended deadline of the original return. If not, they have to be carried forward.
And is it correct that under the IRC's Section 6418, an election to transfer and monetize these PTCs on a filed tax return is completely irrevocable?
That is correct.
Therefore, once the 2024 transfer election was made in 2025, EAL could no longer opt to utilize those credits to offset future tax liabilities. Is that correct?
That is correct.
To accomplish the sale of the 2024 nuclear PTCs, EAL deducted significant brokers' fees, legal fees, and administrative transaction costs from the gross proceeds. Is that correct?
There were costs that were netted against the proceeds. There were broker fees associated with the monetization, and there were some legal fees directly associated with monetization. But some of the other transaction costs would be in place whether you monetized or utilized PTCs.
So is that correct?
It is correct. They were offset against the proceeds.
All right, and then that was the only questions I had for
Proceed.
Ms. Whaley. For Mr. Chang, I have a few. The CCA Group was retained by Entergy Services to market, negotiate, and broker the sale of both the 2024 and 2025 nuclear PTCs. Is that correct?
Yes, that's correct. On behalf of Entergy Arkansas and System Energy Resources.
And just to clarify, what's the CCA Group? What does the CCA stand for?
They're historically, before I joined, I believe it was called ComCap Advisors, and they just shortened it for marketing purposes.
Is it correct that sophisticated creditworthy institution buyers of tax credit will not purchase them without a 100% indemnification guarantee from the utility seller?
Correct.
And under EAL's executed transfer agreements, if the IRS disallows any portion of the tax credit, the purchaser is entitled to a full make-whole cash payment for EAL. Is that correct?
Yes. Yes.
The make-whole obligation requires EAL to return the initial purchase price, reimburse the buyer for the discount, and pay all IRS assessed interest. Is that correct?
Yes.
And is it correct that the 2024 nuclear PTs were sold at a market discount?
Yes. Well, I should correct, at a discount to par, not a market discount. The market rate is the prevailing rate.
Okay. You're saying the
They're sold
PTCs were sold at a discount?
Discount to the par value, yes.
Okay. And the third-party purchasers of EAL's PTCs assume zero financial risk regarding whether the IRS would ultimately uphold EAL's gross receipts calculation methodology. Is that correct?
They do have their own risks of ensuring that they comply with the obligations of the agreement.
And EAL voluntarily agreed to these complete hold harmless terms as a commercial necessity to close the transaction. Is that correct?
Correct.
the last set of questions I have are for EAO witness Lewis,
For who?
Mr. J Lewis.
Yeah, we'll have to wait till he's called.
Oh, okay, I'm sorry. I thought I
That's right.
misinterpreted. I thought he was on the panel.
That's right.
That's all the questions I have for this
You
witness,
may.
Mr. Chairman.
Ms. Parnham, redirect.
Yes, Chairman. Start with Mr. Schott. Mr. Schott, you were asked some questions about the ASC 740 standard and whether or not you had an opinion about whether or not the tax position meets the technical merits required to make the positive assertion. Is that the same assessment or position of reasonableness that the company has regarding the tax position?
No, it's a different standard. With respect to putting a position on a tax return, we generally are looking for substantial authority or a reasonable position. We engaged Ernst & Young, and they wrote a memo that documented that the position was reasonable, that the position that we had developed was reasonable.
And specifically, what about the position is reasonable?
Well, the issue, I guess the uncertainty associated with the issue is the computation of gross receipts. And in the absence of IRS or Treasury guidance, the memo states that the method of determining gross receipts that was utilized or developed by Entergy in the computation of the credits was reasonable.
Mr. Schott, you were also asked some questions about monetization versus utilization of the production tax credits. Do you remember those
Yes,
questions?
I do.
If I could, I don't have a copy of the memo. Speak.
What are you referring to? What memo?
Mr. Chairman, that was part of my submitted testimony.
He says it's part of his submitted testimony.
Exhibit number 6
Is
of
there
my
a page?
testimony.
Is there a page or something we can refer to?
It's exhibit 6 to exhibit PGS 6.
I'm with you now.
Okay, thank you. Proceed.
Thank you, Chairman. In all of your modeled scenarios, is there any scenario under IRS success in which monetization yields lower benefits to customers than utilization?
No.
You were also asked some questions about the compounding of interest and daily compounding. Did you include that daily compounding in your scenarios where you evaluated the net present value differences between monetization and utilization?
Yes, the net present value modeling has various inputs, and when you put one of those inputs in with a IRS disallowance, the model computes the IRS interest on the prescribed method.
And if the company, is there a risk to potential disallowance of the tax position if the company utilizes the production tax credits as opposed to monetizing them?
The risk for is the same either under monetization or utilization of disallowance.
Thank you, Mr. Schott. Ms. Whaley, you were asked some questions about the transaction costs. Can you clarify for the record which of the transaction costs that were included as part of Mr. Schott's and Mr. Lewis's analysis? Which ones of those show up in a utilization scenario?
I believe all of them show up in a utilization scenario except for the brokerage fees to broker the deal to sell them.
And so can you specify which in particular would also show up in the utilization scenario?
Sure. In terms of transaction cost, we would still engage outside consultants to provide us with memorandums to help us understand the accuracy and the technical merits of our position. We would still engage those consultants to assist us with prevailing wage and the documentation associated with it. So those are a couple of examples of costs that would still exist under both methods.
And what about IRS interest? Would that exist under a utilization scenario and a monetization scenario?
Yes, it would.
Thank you, Ms. Whaley. Mr. Chang, you were asked some questions about the indemnification provisions, and specifically the make-whole provisions. In the market for these kinds of, let's step back a second. How many types of transactions like this one has CCA supported or facilitated or brokered?
On tax credit transfers, we worked on almost 60 transactions that total a value of about a little over $9 billion.
In any of these transactions, has the seller been able to complete a sale without an indemnification clause?
No.
And do the terms of those indemnification clauses look similar to the ones that EAL entered into?
Yes.
Right. No further questions. Thank you, Chair.
Thank you. Ms. Anderson? Any recross? Thank you. Thank you all for coming up. Oh, excuse me, Mr. Tate.
Mr. Chang, I'm going to start with you since that's where we finished. On the hold harmless provisions, well, let me take a step back for a second. Were the sale of the nuclear PTCs and the solar PTCs done in the same contract?
No, they were not.
They were separate contracts?
Correct.
Okay. I believe the value of the PTCs is HSPI, but your evaluation of what the market rate was not. Is that correct? Is the value of solar PTCs similar or the same as the value of nuclear PTCs in the market?
No, they're not. The reason is because when you look at the nuclear market, that is dominated by large utility companies, because those types of generation assets are very large, and you don't typically see private equity funds or any independent power producers have the capability to own or operate those facilities. So given the background that the sellers of nuclear tax credits are typically large utility corporations, that tends to garner a premium because buyers want to buy tax credits from sellers that have this type of financial credit worthiness. And when you look at
So nuclear PTCs typically are closer to that par value than solar PTCs would be in the market.
Yes, that's correct.
What if the solar PTCs are being sold by a large utility?
It is then it goes to there's a supply and demand aspect of it. With nuclear tax credits, you typically have buyers that outstrip the amount of nuclear tax credits. With solar, you have not only the utility companies, but a lot of independent power producers and funds and other companies that are developing solar assets that are in the market to sell production tax credits.
Okay. So generally speaking, solar is not worth as much in the market as the nuclear production tax credits.
Correct.
Do you typically have the hold harmless provisions in the contracts for the solar PTCs, just like we had here with the nuclear PTCs?
Yes, that's correct.
Okay. I think that's all I have for Mr. Chang. I don't know if you have any questions for him.
I want to say this panel has been very helpful. Mr. Stotts, we really appreciate your affidavit. It's very helpful and very, very clear in what you testified to, and we appreciate that. We appreciate each of you coming here, and you may stand down.
Thank you.
Come on up, Mr. Lewis.
All right, so EAL calls Jay Lewis. And Chairman, we would ask the same accommodation for Mr. Lewis. He has just the files that were in the filing on his desktop in case you all have detailed questions about the Excels.
Okay. Thank you.
Certainly. Do we need to wait for her before I
Yes,
proceed?
let's
Okay,
go.
thank you.
I could tell he was standing there long enough. He needed to find a spot to set some of that stuff down.
I appreciate that.
Yeah.
He was ready to go.
We appreciate your coming back.
All right, Mr. Lewis, can you please state your name, title, and business address for the record?
Sure, my name is J.A. Lewis. I am a principal in ASD at Work, which is an LLC through which I do consulting work. My address is 3 Melrose Court, Monroe, Louisiana.
And are you the same Jay Lewis who filed direct testimony in an exhibit on February 26th and an errata to that direct testimony on February 27th, direct testimony on March 20th, rebuttal testimony and exhibits on May 7th, Sir rebuttal testimony on June 5th, and supplemental testimony and exhibits on August 14th, 2026?
I am.
And if I asked you those questions in those testimonies today, would they be the same?
They would, except for one minor typographical correction I need to make. In my supplemental testimony, which was just recently filed, on page 11 of that supplemental testimony, on line 1 of page 11, I have a table reference, which is stated as table 2. That's a typo. That should be table 3. That's the only change I would make, Ms. Law.
Thank you. So consistent with Judge Hickman's pre-hearing email and your comments earlier today, I believe all the testimonies and exhibits are admitted into the record, so we will tender Mr. Lewis.
Thank you. Mr. Parks, this is your chance.
Thank you, Chairman Webb.
Welcome.
Morning, Mr. Lewis.
Good morning, Mr. Parks.
Just a couple. Regarding the solar PTCs, is it correct that the APSC's order number 15 in docket 20052U explicitly held that the 30-year amortization for Walnut Bend was narrowly tailored based upon the unique and specific facts and is not applicable generally to any other EAL resource?
Yes, that's my understanding, is that it was stated as to not be a precedential finding in that order.
And then with regard to the tariff itself, would you agree that the tariff is pretty specific when it outlines what happens in an IRS, an unfavorable IRS position? Is that correct? With regard to getting those funds back from customers, would you agree that that's correct? It's pretty specific.
I would agree that it lays out the costs that are to be recovered, and it lays out the period over which those costs will be recovered. So yes, it's pretty specific in that regard.
But with regard to returning the principal to customers, there's really nothing in the tariff, is there? It's you in your testimony you're stating you defer that until the IRS issues guidance due to uncertainty regarding the amortization period and the unknown magnitude of the proceeds.
Yes, the tariff certainly doesn't speak to what would happen in the event of a favorable IRS determination in terms of the period over which the funds would be returned to customers, what mechanism would be used, all that is left open.
There's nothing in the tariff regarding that.
I do think that my recollection is the tariff indicates that the company at that time would come to the commission and then initiate a proceeding or proposal to return those funds.
But you would agree that with regard to the clawback, it's pretty specific with regard to returning the principal. There's nothing in the tariff.
I agree with that.
And then in your I believe it's document 42. Which is your rebuttal testimony. And then I believe it's on page 11. Lines 3 through 8, you're talking about the pillars of fungibility.
Page 11, is that right?
I believe that's right. Let me.
Yep, I've got it. Right.
And again, it's the 3 pillars of fungibility. The last one being all liabilities are fungible sources of funds that are used to fund each and every asset of the utility. Is that accurate?
That's my understanding of one of the principles that underlies the modified balance sheet approach.
And that's what you prefer for the solar PTCs.
Yes, in the sense that I'm stating that analysis with regard to the staff's recommendation that the solar PTCs be dealt with in a separate rider like rider NPTC. My point is, with regard to the modified balance sheet approach, that's kind of pulling a source of funding, the PTCs, and associating with a specific asset, which is not the Commission's general practice in using the modified balance sheet approach. It attributes all sources of funds to all assets of the company, is my point.
But for the nuclear production tax credits, you propose that returning the net proceeds to customers or ratepayers should be deferred and handled holistically alongside future capital recovery issues for Arkansas Nuclear 1, specifically plant relicensing and depreciation studies. Is that accurate? Is that correct?
Yes, it is. And I can explain, the differentiation.
I'm just asking if that's correct. I'm sure your attorney
correct.
will allow you to redirect.
That's fair.
And do you know that much about the Geyser rider?
I was involved in the docket, so I have certainly some familiarity with it.
Is it true that EL currently uses the Geyser rider to charge current customers for financing costs of strategic investments that are still under construction, even though those plants will only serve future customers? Would you say that's accurate?
I believe so. Now, I was involved with the docket that implemented the Geyser rider, not the docket that actually put assets into the rider, so I'm not familiar with the specifics of what's being recovered currently. But I agree with what I believe your point is, which is the Geyser rider provides for recovery of the financing of CWIP, so those costs are recovered currently. Yes.
And part of the nature of that question was there's a fair amount of discussion about intergenerational inequity, right, in the docket.
Mm-hmm.
Is that accurate?
There is.
That's all the questions I have, Chairman.
Thank you. Any redirect?
Yes, briefly, sir. Mr. Lewis, Mr. Parks asked you about the 30-year amortization that you proposed for the solar PTCs. Do you recall those questions?
I do.
And I think he referred to a prior docket where the commission determined that their decision there to use 30 years would not be precedential.
Right. I remember.
Right. Can you explain, though, why you are proposing 30 years here?
Sure. It's fundamentally an issue of matching the costs of the resource with the benefits of the resource, if you will. As the asset is depreciating, it's being charged to customers. The way I see these PTCs is they're mechanisms provided by the government to reduce the cost of this generation. So it makes the most sense in terms of providing those benefits to all the customers who will receive those that generation from those resources to amortize them over the life of the asset, to essentially match the life of the PTCs with the life of the asset. That's the nature of my point.
So the company did not propose 30 years simply because it was used for Walnut Bend or approved there, but rather because that's what you believe the evidence supports.
I believe it's the best way to handle the credits, yes.
And then I think you were also having a discussion with Mr. Parks about why the company proposed rider in PTC for the nuclear PTCs.
Yes.
Can you elaborate there on why that was the case?
Sure. The distinction I wanted to make there is that, the nuclear PTCs by their nature are different than the solar PTCs, as I outlined in some of my testimony in this docket, because of the things that have already been talked about, the uncertainty as to the amount, as to when they'll be resolved, et cetera. So, including those in rate making currently, affecting customers' rates currently through, a base rate case or an FRP or something of that sort, in my view, would be unwise until we know what's going to happen with those PTCs. So it's the fundamental uncertainties around the PTCs that cause me to believe it's appropriate to treat them differently than the solar PTCs in rate making.
And those uncertainties do not exist with solar PTCs?
No, there's no uncertainty around calculation. That gross receipts issue doesn't apply. They've been around longer, so to speak, so the same uncertainties don't apply.
No further questions.
Thank you. Any recross?
No, Chairman.
Thank you. Commissioner Anderson?
No questions. Thank you, Chairman.
Mr. Tate?
I think I just have one question. In regards to your supplemental testimony, I asked Mr. Palmer earlier about the debt rate applied in the alternative proposal. Can you tell me what that is?
Yes, the debt rate that we used in the modeling that you've seen in this docket was 3.37%. And the way that was determined was essentially taking the company's most recently approved weighted average cost of capital, removing the equity components of it, and computing the company's weighted average cost of the other sources of capital.
So why not just use the cost of debt in its most recently approved filings?
Well, that would be one way to do it. Obviously, the Mississippi's different in the sense that it doesn't use the modified balance sheet approach. So simply trying to respect that approach in terms of how this commission determines weighted average cost of capital. Fundamentally, the MBSA treats all sources of funds for the company as sources of capital, so that's why those are included. But that's the distinction.
Okay. I think that's all I have. Thanks, Chairman.
Mr. Lewis, I have one question that may tie to your correction initially. I'm looking at a chart provided on page 833 of Exhibit 2. I don't know if that's Exhibit 3 or 2. My notes say Exhibit 2. I would like to ask about the costs that are included in that chart. Are we looking at the same thing? And I'm of the belief there's a mistake, an unintentional mistake. I just want to get it clarified.
Okay, so this is in Exhibit 2 to my testimony, is that right?
Yes.
Okay, so it's the spreadsheet itself.
Well, maybe let me just ask you, you may know the answer without looking it up. In there, it explains fees, and in there, it shows $5,000 paid to the Friday Law Firm for the release of property tax liens and an engineer's certificate. Are you familiar with that?
Chairman, before Mr. Lewis answers, that exhibit is highly sensitive, so we may need to go in camera.
Oh, okay. Let's go in camera then, okay? If you're not signed a non-disclosure, you need to step out in the hall.
Just wanted to follow up on the question I asked earlier. In calculating that 3.37 debt rate, do you have work papers associated with that? I'm still struggling to figure out how exactly did you pull the equity out of the pre-tax or post-tax whack?
I believe it's the pre-tax WAC that is pulled out of, but we can supply that information. I don't think it's in one of my filed exhibits, that calculation, but we can certainly.
I wasn't able to find it. I was looking at sheet 20, I think, and what I believe is exhibit 2 to your supplemental.
Yes, that's exhibit 2 to my supplement.
And that's where I see that 3.37 rate, but I did not see a calculation of how you came to that number.
Yeah, I believe that's correct,
Okay.
Commissioner. And just for informational purposes, it's a big spreadsheet. And there are, I think, 4 scenarios that are related to that, what we call the EML case. It's actually scenario 23 that we used in my testimony, but you'll see the same 3.37% rate.
Okay, so you can provide work papers or something showing us how you came up with that calculation?
Yes. Yeah.
Okay. Thank you. That's all I have, Chairman.
You may stand down.
Thank you, Chairman.
Invite our guests back in. Have we invited them in? Good. Why don't we take about a 15-minute break, come back about 10 after Be seated, and we're back on the record. Mr. Parks, call your witness.
Chairman, before we move
Yes.
on to staff, I wanted to offer that Mr. Lewis was able to get an answer to Commissioner Tate's question, and we're still happy to file that work paper, but I didn't know if it would be helpful for him to walk through the calculation in case you had additional follow-up questions that he could answer today. So I wanted to offer him again.
It's your call.
Yeah, that'd be helpful if you're okay with that, Chairman.
Call Mr. Lewis back up. Yeah,
Thank you.
thank you. You just thought you were going to get to sit down.
No. So, should I just
He'll ask.
provide the additional information or wait for Mr. Tate to ask?
You want to ask the
additional
question, Mr.?
Go ahead and, so the hopefully what you're going to tell me is how you calculated that 3.37 debt rate.
Yeah.
Okay,
And-
if you'll walk me through that.
And we'll have a work paper that gives the actual calculation, but I wanted to give you the specifics I discovered during the break, and that is that we used the weighted average cost of capital from the company's 2025 FRP filing for the 2026 projected test year. And what the company did, or what we did in calculating the 3.37 was, as I indicated earlier, we removed the equity components of cost of capital and essentially just recalculated the WACC as if there's no equity in the capital structure. So you kind of gross up the debt component. So, just to use broad numbers, assume there are, $2 billion of debt and $1 billion of equity. We calculated a cost of capital for the $2 billion of debt and other components of the capital structure. Just removed the equity and used that 2026 FRP test year, projected test year, to calculate the 3.37. We can provide a work paper for that, but that's how it's calculated. I should note, as we discuss it, that it's a monetization scenario, that EML scenario, which again, reflects the benefits of monetization that are reflected in our testimony. There's been discussion of this morning of the various transaction costs and hold harmless provisions, et cetera. Those are a part of monetizing. In order to monetize, you've got to incur those costs, and they're all included in those scenarios. And monetization continues to be significantly more valuable in every scenario than utilization. So I wanted to just make that comment because that scenario is a monetization scenario.
Okay, that's helpful. You said you'll still file the work paper.
We'll
Thank you.
we'll put a work paper together for you.
Thank you.
All right.
You may stand down. Mr. Parks, we're ready. Mr. Hilton, we're ready. I short circuit the process. Get you on up here.
Staff calls Jeff Hilton. Could you please state your name and business address for the record?
Sure. Jeff Hilton, 1000 Center, Little Rock, Arkansas.
And who is your employer?
Arkansas Public Service Commission.
And what is your title?
Director of the Gas and Water Section.
On whose behalf are you testifying today?
The general staff of the commission.
Are you the same Jeff Hilton who filed direct testimony on April the 16th, 2026?
Yes.
And the same Jeff Hilton who filed surrebuttal testimony on May 29th, 2026?
Yes, sir.
Do you have any corrections or additions to your testimony at this time?
No, sir.
Mr. Chairman, I tender the witness.
Thank you. Mr. Breadlow, Mr. Breadville, excuse me.
Yes, sir, Chair. Mr. Hilton, Jay Breedveld, 4-Inch, Arkansas. How are you today?
Fine, sir.
Can you hear me okay?
Yes.
Okay. In your direct testimony, you recommend approval of the monetization of nuclear production tax credits, correct?
Subject to conditions. That's correct.
All right. And would you agree that the only way to obtain the benefits of the nuclear production tax credits in current day is to monetize those tax credits?
Based on the assumptions that I had reviewed and the timing of when there would be availability to utilize the production tax credits by the company, I think that yes, that's correct.
All right. And then you recognize that the risk of the IRS not agreeing with the valuation that Entergy Arkansas has placed on the nuclear production tax credits is the same in either the monetization or utilization scenarios in the absence of IRS guidance. Would you agree?
I think that the company has utilized what could be considered an aggressive position in terms of gross receipts, and so yes, it would be potentially harmful either way.
Either way, meaning either as a result
Utilization
of
or monetization, yes, sir. Just more so with monetization.
Would you agree that there are transaction costs associated with monetization that are separate and apart from indemnification?
Sure.
For example, legal fees or consulting fees. Would you agree those are transaction fees associated with monetization?
Yes, sir.
All right. And would you agree that there would also be some internal costs associated with similar activities of marketing, valuation, determination of eligibility of tax credits, and those internal costs would be attributable to the monetization transaction?
Yes, sir.
And then another cost is the discount to the value of the nuclear production tax credit that is given to the buyer. Is that correct?
Yes, sir.
And would you agree that if it's reasonable to monetize the nuclear production tax credits, it's reasonable to incur those transaction costs?
Yes, sir.
Okay. That's how you get to the net proceeds, right?
I think that's correct, yes.
All right. Do you also understand that it is necessary for the seller, EAL in this instance, to indemnify the production tax credit buyer to obtain the benefits of monetization?
Do.
Okay. You may want to speak a little louder into the microphone there.
Sorry.
Now, going back to the discount to the valuation of the nuclear production tax credits that are given to the buyer, those dollars are not available to EAL as a source of capital to support utility operations. Is that correct?
The discount component?
Correct.
That's correct under the monetization scenario. That would be correct, not utilization, obviously.
So I want to talk a little bit now about the indemnification cost. You take issue with EAL's proposed recovery of indemnification cost from customers, correct?
Take issue with the company not having any risk shifting it all to ratepayers in terms of if an aggressive position taken in terms of gross receipts is not upheld. That's correct.
And to be clear, we're just talking about the indemnification costs that you would suggest there be some sharing of risk. Is that correct?
That's correct.
Let's bucket those costs. You heard Mr. Palmer say that penalties would never be sought, so that's not part of your bucket. Is that correct?
I think that was in the FERC filing, and I think that's something he recognized, yes.
All right. And then there are interest costs, correct?
IRS interest?
Correct, yes.
Yes.
All right. But there would be interest exposure under either scenario of monetization or utilization. Is that correct?
I believe that's correct. The amount might vary due to the discount rates you mentioned, that the purchaser had received, and full indemnification would include full reimbursement, is my understanding.
Okay, so what you're really getting at is the difference in interest cost as between a monetization or utilization scenario.
I was just addressing the monetization scenario at the moment.
Okay, but I want to just make sure I understand then, if there would be interest costs incurred regardless, do you think those costs should also be shared through some risk allocation? And I'm just talking about the interest cost.
I don't see why they wouldn't be.
Okay. All right, let's talk about the discount.
The purchaser's discount or something else?
The discount to the nuclear production tax credits given to the purchaser, yes.
Thank you.
All right. In the event that the IRS does not agree with EAL's valuation, is reimbursement of that discount a cost related to an IRS disallowance in your view?
Can you ask me that again, please, sir?
Yeah. If the IRS does not agree with EAL's evaluation of the nuclear production tax credits, and EAL has to reimburse the purchaser the discount or some portion thereof, is that considered, do you consider that to be a cost related to an IRS disallowance as you've described it in your testimony?
I think the one, it may be caused by the other, but that doesn't necessarily go to who should pay those costs or who is at risk.
Who do you think should be at risk?
Well, I think that, and I recommended in testimony that it be shared at least to some extent between the company and ratepayers. It seems inappropriate to me, regardless of any quantification, that the company should share in that risk, especially with the tax position that is deemed to be uncertain.
All right, but we agreed earlier that the discount to the valuation is a prudently incurred cost that's necessary to achieve monetization, right?
The discount paid to that the purchaser enjoyed?
Yes.
Okay. Yes, I agree.
Okay. Nevertheless, you would not allow full recovery of that cost if the IRS did not later agree with the EAL's valuation. Is that correct?
It would be a component of the cost of indemnification that wouldn't exist with utilization. So, but again, I think that there needs to be recognition and sharing of risk between both shareholders and ratepayers.
Okay, but the effect of sharing that risk as you propose is that EAL would not recover a cost associated with the transaction, correct? Or a portion thereof.
I guess I don't look at it that way, no, sir.
Well, under your proposal, EAL would be responsible for some portion of the value of the discount in the event that the IRS does not agree with EAL's valuation. True?
I think that has to be reimbursed, yes.
All right, but you don't consider that to be a disallowance?
No, sir. I think it's a sharing of risk that needs to be recognized by the company. And, I think it's appropriate to include that in any scenario.
All right, what we discussed earlier, that the risk of the IRS not agreeing with Entergy Arkansas on valuation is not unique to monetization, correct? It applies equally to utilization.
Which component?
That the risk of the IRS not agreeing with EAL's valuation is equal regardless of whether you're in a monetization or utilization scenario. Correct?
I think that the position taken by Entergy is born either way. I think it is either way, but I think that the monetization results in a larger amount than if it was utilization.
In your view, is symmetry a valid rate-making principle where benefits follow burdens and vice versa?
Well, I believe in the basic maxim with in terms of rate cases where it is a regulated rate that should result from a revenue requirement that's appropriate.
But in establishing the rate and based on a revenue requirement and how it should be recovered from customers, how that revenue requirement should be recovered from customers, do you agree that symmetry is a valid consideration such that if there are benefits associated or embedded in the revenue requirement and there are burdens embedded in the revenue requirement, they should follow each other?
I can't say that should explicitly follow under the scenario you're describing.
Okay. But looking specifically at your proposal, the customers would receive all of the benefit of whatever the outcome is of the valuation of the nuclear production tax credits, correct?
No. I mean, I'm not clear what you mean that all of the value. You're talking about a return for a period of possibly 5 years or maybe less?
I'm sorry, speak up, sir, if you don't mind.
Pardon me. When I look away, it doesn't pick me up. Are you talking about the return that's being offered in the rider that could be in effect for up to 5 years, possibly?
I'm talking about at the end of, or at the point in time when the IRS provides guidance or is otherwise resolved as to what the value of the nuclear production tax credits will be. At that point in time, do you, in your proposal, the return of and on the value of the production tax credits would flow entirely to customers, correct?
No, I don't think that's correct. I think that what's not recognized in using the overall weighted average cost of capital as determined in Arkansas, it does specifically exclude zero cost capital. It includes them rather, and thus reducing the amount given to ratepayers. The company has, for example, in the Gaja rider, illustrated that the appropriate level of external financing would be a higher rate. And so therefore, I think there is a mismatch in that regard.
Are you suggesting that the company's proposal to use a weighted average cost of capital is not sufficient to compensate customers? Is that what you're saying?
I think in the context of the overall, analysis, I think it's a factor. But I'm not suggesting or arguing for a different rate. I'm just noting the fact that the company, the avoided cost by the company should be considered at a little bit higher rate than what is being paid back to ratepayers or being paid to ratepayers, excuse me. There's no principal returned at all in this this initial period.
And I'm speaking to the period after the initial period, once there is IRS resolution on the valuation of the tax credit.
I'm sorry, can you ask the question again?
Yes. In that context, under your proposal, customers would receive return of and on the value of the PTCs as ultimately determined by the IRS, correct?
I think that's the thought on it.
Okay. But if there is any disagreement from the IRS on the valuation of the production tax credits, the cost associated with that would be split 80-20, 80 to customers, 20 to the utility under your proposal. Is that right?
That's right.
Okay. And I did not see any empirical analysis to support your proposal of an 80-20 split in your testimony. Did I overlook something?
I don't think you did. I think that's a recognition of risk. I think there's a difference, inherent difference there, based on what was provided by the company. That seemed to be the appropriate response. I do know, looking at certain factors in the net present value determination, that there was certain considerations that staff had initially discussed internally, at least, and what continued to show, that showed up in my testimony.
So are you saying it's basically just your subjective determination of what is a fair allocation of risk?
I think it's subjective, yes.
Okay. All right, but at the end of the day, your proposal is a form of risk allocation. Is that right?
That's correct.
And have you reviewed what we've talked about here today as the approach the Mississippi Public Service Commission has taken with respect to the treatment of the nuclear production tax credits?
Briefly, yes, sir.
All right. And what is your understanding of how that methodology allocates risk of the IRS not agreeing with the company's valuation of the tax credits?
I think that they're deferring, and I'm not clear why they have chosen what they've chosen and why that was the agreement was allowed in those jurisdictions. All I can do is say what we think is appropriate, staff thinks is appropriate in Arkansas, especially since we're carrying a pretty large share with the A&O, being at, a larger percentage.
Having read the supplemental testimony and having an understanding of the approach the Mississippi Commission has taken, have you developed an opinion on whether that's a reasonable approach?
I think that any ultimate decision obviously is purely in the hands of the commission, but I think it should recognize some sharing of indemnification costs. 100% is, one way to get there, or a lesser percent. But at the same time, I think that ratepayers need to get some consideration from the time that the company, what I think is the ratepayers, they essentially are, if you will, the owners of in paying for the tax credit. And so for that money to have been passed to Entergy Arkansas and no recognition for up to 5 years at least, then it's difficult to say that's a reasonable conclusion in my mind.
And again, does that go back to your notion that for some reason the WAC is not adequate compensation to customers?
In part, I think it's overall conceptually that the company who is taking this position, that is recognized that it's a FIN 48 amount that would not be, more likely than not to succeed. And so I think all of those things are components or factors in the recommendation made.
So let's talk about that a minute, because you mentioned, or you characterized the company's tax position as aggressive earlier. Do you recall that?
I do.
Okay. Are you saying, is that based on any IRS guidance that you?
That is based on the various revenue levels, the gross receipts options that the company has discussed. I think Mr. Schatz discussed it, but it was discussed previously as well.
Have you done any independent research around quantification of gross receipts as required in this instance?
Any independent research?
Yes, sir.
I have not.
All right. Do you have any reason
I
to?
just know that it's a position I haven't been taken, there's no guidance on it. And, you know, if there was another methodology that could have been used that would not have resulted in this same FIN 48 recognition, then it potentially would be preferable. But I can't speak to that. I don't think that was ever specifically
Sorry, I'll let you finish your answer.
quantified, was what I was going to say.
Are you suggesting that the company could have claimed the nuclear production tax credits and done so in a manner that would not have resulted in an uncertain tax position?
Potentially.
On what basis do you have that opinion?
Well, the fact that there's a variety of, or a few alternatives into making that determination of the level of gross receipts. So with that consideration, and that there is potentially a less aggressive position, a position that might yield a better result or a less potential for disallowance.
In the absence of IRS guidance, can you say one way or another whether any position or any approach would be better than Entergy's approach?
Better in what regard?
Well, I'm speaking to your commentary that you think it's an aggressive method, and you've mentioned that there might be other methods out there, and I'm asking, in the absence of IRS guidance, can you say that those other methods would yield a result that was not a uncertain tax position?
I can't say that with certainty. I don't know the specifics of the alternatives that were discussed recently.
All right. Did you review Mr. Schott's supplemental testimony?
Yes, sir.
And did you review the Ernst & Young memorandum attached there too?
I'd have to look at that one to tell you.
It was his Exhibit 6.
Let's see.
And I can cut it short. Maybe it was addressing the company's methodology for determining gross receipts to value the production tax credits. Do you recall that?
I'm sorry, I don't right now.
All right. Do you recall whether that the Ernst & Young memo determined that the company's methodology was reasonable? And if you don't, that's fine.
I'll have to say I don't at the moment.
All right, last item. I just want to talk about the period of return of the nuclear production tax credits. I think your recommendation and your filed testimony is a period of 2 years following IRS resolution on valuation. Is that correct?
That's correct.
All right. Did you provide any empirical analysis to support your proposal of 2 years?
Well, I think that was looking at the amount and what has happened in the past with Entergy. There was a tax amount for unprotected ADIT that was in a docket 1806U that was $345 million, or grossed up 466 estimated, that was given back over a couple of years. And so I think that was a basis for that, as the former director and I discussed.
All right. Well, in your view, is it absolutely critical that the commission decide today over what period of time to distribute of what appears to be an uncertain amount at this time?
I think it's helpful if you're coming to terms on all components of this rider, so to not defer something until later when you're looking at something that should be considered in its entirety.
And does your approach take into consideration any flexibility to address subsequent tax years if EAL is able to claim additional nuclear production tax credits for, say, 2026, 27, 28, or 29?
I think the analysis needs to be updated each year, but I think it it doesn't necessarily guarantee that they would be included. I do think that if there is any IRS guidance, whatever the source may be, audit or otherwise, that immediately changes the scenario for, the timing of, and, actually starting to give back the level of both principal and interest to ratepayers. And so once that happens, assuming it's favorable, then it would definitely need to be reviewed for any subsequent years.
So just to make sure I heard you correctly, what I took away from your answer is that you're recommending 2 years today, but we would check and adjust later when more information is known.
I don't think that that's exactly the way I characterized it. I think if something changes the scenario, then what this is predicated on potentially would change, but that's not, so it's not saying that there couldn't be additional information that would alter the level or the way that this whole thing is treated. Certainly, if it was allowed, there would be no reason to make any recommendation related to indemnification and so forth that has to do with disallowance.
Going back to the proceeding that you referenced earlier, that was a sum certain that was known at the time the decision was made. Is that right?
It was an estimate, but I think it was pretty good estimate.
Okay, but here today, we don't know what the value of the nuclear production tax credits will be until we obtain IRS guidance, correct? Or a determination.
Don't know the value of it.
Right.
Well, I think given the facts as they are known, then there is a recognition of that.
We know today what Entergy has valued the production tax credits at. Is that what you're saying?
And what they've been sold for.
Correct. But at the end of the day, we still don't know whether the IRS is going to agree with the company's valuation of the tax credits sitting here today.
I think that's correct, yes.
All right. Do you know what rate levels are going to be in 3 to 4 years from now?
The rate levels related to this or relate to something else?
You're right. I should be more precise. Do you know what EAL's retail revenue requirement will be in 3 to 4 years?
I can't specifically say no, but I haven't tried to quantify that at this point. I assume it's going to be, because there's continuation of their formula rate plan, that it will be some level that's capped at, but then you've got a multiple of a myriad of riders that also, so there's a variety of things that are being factored into that all would have to be considered.
Okay. And so if your proposal was to be adopted, would that affect the commission's flexibility to address the overall revenue requirement of the company through either the FRP or other rates and riders?
Would a decision on this issue affect that?
Yeah, if you dictate today, if you ask the commission to dictate today that the funds or amounts should be returned to customers over a period of 2 years, does that, in your mind, wouldn't that limit the flexibility the commission would have to address EAL's revenue requirement farther in the future through either the FRP and the riders in totality?
I don't think it does.
Okay. I think that's it, Chair.
Mr. Parks?
Jeff, to the initial question, do you want to elaborate on the conditions? You'd indicated that subject to conditions.
Right. I'm sorry. Thank you for the reminder. I was involved with the initial review of this with under a pretty short time frame, that in the summer in 2025, and my recommendations were discussed and provided to the director then. But my conditions essentially are similar to what was in testimony. I mean, or at least they're the same. It's included, but I think there was the various issues I saw, for example, or things that may have been identified already in this hearing, but there's a little uncertainty in terms of, you know, the use of the 8% amount as an appropriate discount rate. I think that the timing of the availability of the company to utilize the tax credits in regard to the net operating loss, that's a very much an uncertainty, in at least from my perspective. And I think admittedly that there is potentially changes due to a variety of things, one of which might be the outcome of the monetization as opposed to utilization of these various tax credits. And as I mentioned, that I think that the position being subject to FIN 48 was certainly a consideration in my mind, and as the director and I had discussed, and ultimately one of the reasons why it got included in my testimony.
And you're
one more thing, sorry. And then obviously the discount due to the purchaser, that's part of monetization.
And your subjective analysis, that was prior to anything with regard to EML, correct? I mean, that you put together your analysis prior to any of the other scenarios provided in supplemental testimony, correct?
That's right.
Would your recommendation have changed had this been done prior to would your recommendation have changed had this been done with commission approval rather than as a result of an investigation docket?
I'm sorry, I'm not sure I'm following that question. Can you ask again?
Do you believe, would your recommendation possibly have changed had this been done with the commission's approval
You mean if
rather
the commission had
than
approved it up
being
front?
opened as an investigation docket?
I'm sorry to interrupt. You mean if the commission had approved it up front in 2025?
Yes, sir.
I don't think so, but I assume there would have been further guidance from the commission on all of these things being considered.
Okay, that's all I have, Chairman Webb.
Let's go ahead and break for lunch. We'll come back at 1 o'clock. Be seated, please. Mr. Hilton, if you'll come back up. Mr. Parks, had you completed?
Yes, sir. I think it's all yours.
Well, thank you. I don't want him, but I'll take it. It is after lunch, y'all. You have to bear with us, okay? Ms. Anderson, do you have any questions?
Not right now, Chairman. Thank you.
Mr. Tate, do you have questions?
Thank you, Chairman.
Thank you.
Afternoon, Mr. Hilton.
Good afternoon.
I want to understand staff's position on the company's initial proposal. Tell me if I'm framing this correctly. You're proposing an 80-20 split because you think if there's going to be some shared benefits, there should be some shared risk. Is that a fair assessment?
Well, I think that there shouldn't be any deferral to ratepayers of the risk.
Mr. Hilton, get closer to the mic.
I'm sorry. Did
problem.
that come through?
Yes, sir.
Okay.
Thank you.
Is there any benefit to the company in monetizing the production tax credits?
Oh, I think so.
Can you explain what that is?
I think they have the benefit of the immediate use of those funds at the Arkansas weighted average cost of capital. I think that's the most significant reason that they would prefer this type of mechanism. At the same time, recognizing they may not be captured timely if utilized.
Okay. Did you get a chance to review the alternate proposal that was presented in the supplemental testimony?
I'm sorry, which?
The alternative proposal, the one that would indemnify ratepayers from the risk of a negative IRS determination, but would use a separate, something other than WAC, and would hold that, the proceeds and what is accrued until an IRS determination.
I did read it. Yes, it was I guess the debt level was what I believe was discussed as something that's to be accrued, which was not part of the conditions or part of the testimony that I had filed. I think the consideration was to get some level of return to ratepayers in the interim. So is that, there's nothing, I'm not saying that that's not, may perhaps be appropriate. It is not, it doesn't accomplish all of the objectives that staff had in mind.
Sure. And we'll come back to that one specifically, but having had an opportunity to look at that proposal, is staff supportive of that proposal, or is staff still recommending the initial proposal with some type of split like 80-20?
I think the initial is still on the table for us.
Okay. You mentioned one of the conditions being having something go to ratepayers immediate. Is that right?
Yes, sir.
And why is that a priority for staff?
Well, I think it's appropriate to at least recognize some level of return associated with the money that's been received. When you look at it from the perspective of, these credits are essentially paid for by ratepayers. To say that they give no return until some future period that's estimated to be approximately 5 years, it doesn't seem like that's an appropriate conclusion to this.
With the initial proposal, if money goes to ratepayers immediately and you end up with the IRS determining that the position Entergy took was not correct, you would have to, ratepayers would end up having to pay money back to Entergy to cover the cost of that under the agreement. Is that right?
Under what staff proposed?
Well, under either proposal, because even under an 80-20 split, right? Ratepayers would still be on the hook for indemnifications costs, even if it was split with the company.
Some level, yes, sir.
And you think returning money immediately to ratepayers is more beneficial than the downside of having to ask ratepayers to pay more to cover those indemnification costs if that outcome, if we end up with that outcome? Does that make sense?
It does, and the best way I can say to answer that is that I think both criteria are important. I think the other criteria was to a speedy return assuming the IRS approves it. So there was three, essentially recommendations included, and those two are, I think, both important. I can't say they're equally important, but I think that it makes sense to recognize some level of sharing. I think that I think it would be inappropriate to result in an amount where the company was able to get all of the money up front, but with potentially no risk that might happen subject to this position that they had taken. So I think there's a trade-off to those two, but I don't know that one should deny the other.
Well, I understand your position that once the IRS makes a determination that the money should be returned to customers quickly, what I'm asking, I guess, is the evaluation between the two proposals, which is Entergy holds the money, it accrues some level of debt return, and once the IRS makes that determination, we can discuss, how quickly all of that is returned to customers if it's positive. If it's not positive, then customers wouldn't owe anything, right? The other proposal being, sure, they start seeing some of the, they start seeing that WAC return immediately, but if the IRS determination is not positive, even with some type of split with the company, ratepayers are likely going to have to pay back at least what they received as a WAC return, if not more, to cover some of those indemnification costs. And so what I'm trying to weigh is the risk that ratepayers will have to bear, even if it is, split at least in some portion with the company, is that worth that higher rate of return versus indemnifying all of ratepayers from all of it, but having a lower return and waiting till the IRS determination to flow that back?
Well, I think there is a trade-off there that's, potentially would be reached some level of return up front. But I do agree that the lesser amount of ratepayers being required for any of the indemnification costs is desirable. So I guess to answer your question, I think it's not an inappropriate result.
I'm sorry, what's not an inappropriate result?
The supplemental recommendation.
Okay. Are you familiar with the cost of debt he used that Mr. I'll have to go back and look now. The cost of debt that was used as in the calculation of what that would look like in the alternative proposal. Are you familiar with that?
Well, I heard his testimony, but I can't say that I've.
So you're not sure how that number was arrived at exactly, or agree whether that's appropriate?
I can't sit here and agree right now. I do realize I think recognize that's an appropriate way to determine it.
I want to talk briefly about the solar production tax credits. If I remember correctly, your recommendation was to use the FRP to return the Walnut Bend PTC proceeds. Is that correct?
Yes, sir.
Why the FRP for those PTCs specifically?
Well, I think it's more why not for the other two. And I think that when you're looking at monetizing it and a shorter life, it's more important to make sure that that level is actually received by ratepayers. I think the FRP is may limit, based on the usage that I've seen in the past, where it's typically well above the cap.
Where you say you sort of turn the question a bit. I guess I'm going to go back to the original question. Why is it appropriate to use the FRP for the Walnut Bend PTC proceeds?
Well, I think that's a recognition of what has already been approved as a longer life. The recommendation that staff made for the other two is the shorter period of time to return it. And so I think it becomes a little bit more important to recognize the other two in a separate rider. I don't have a strong reason for including Walnut Bend in the FRP. That was just the recommendation that was determined.
Okay. I think that's all I have, Chairman.
Thank you. Ms. Anderson? I have no further questions. You can stand down as well.
Thank you, sir.
Mr. Parks? That's the word I wanted to hear. Anything needs to come before us today? Anything further? We appreciate all of you here. Appreciate coming back after lunch. We're going to leave the record open in the event there's some post-hearing commission questions. Otherwise, if there's nothing else to come before us, we will stand adjourned. Thank you all for being here.